Citing Betts v. Brady, 1942, Justice Roberts delivered the opinion of the court. Petitioner and indigent was indicted for robbery. His request for counsel was denied because local practice permitted appointment only in rape and murder prosecutions. Petitioner then pled guilty and elected to be tried without a jury. At the trial, he chose not to take the stand. He was convicted and sentenced to 8 years imprisonment. The Due Process Clause of the 14th Amendment does not incorporate, as such, the specific guarantees found in the 6th Amendment through a denial by the state of rights or privileges found in the 6th Amendment, although a denial by a state of rights or privileges specifically embodied in that and others of the first 8 amendments may, in certain circumstances or in connection with other elements, operate in a given case to deprive a litigant of due process of law in the violation of the 14th. Due process formulates a concept less rigid and more fluid than those envisaged in other specific and particular provisions of the Bill of Rights. Its application is less a matter of rule. Asserted denial is to be tested by an appraisal of the totality of the facts in a given case. Petitioner says the rule to be deduced from our former decisions is that in every case, whatever the circumstances, one charged with crime who is unable to obtain color to the argument, but as the petitioner admits, none of our decisions squarely adjudicate. In Powell v. Alabama, ignorant and friendless N-word youths, strangers in the community without friends or means to obtain counsel were hurried to trial for a capital offense without effective appointment of counsel, even the counsel casually appointed to represent them. Appointment of counsel was likewise a denial of due process. But added whether this would be prosecutions. Every court has power, if it deems proper, to appoint counsel where that court seems to be required in the interest of fairness. Gives point to the principle that the state should this the petitioner did not and did in the present case. Such trials, as Judge Bonham remarks, are much more informal than jury trials, and it is obvious that and of ordinary intelligence and ability to take care of his own interests before been in criminal court, pled guilty to larceny and served a sentence that was not wholly unfamiliar with criminal procedures, and he had once before been in criminal court, pled guilty to larceny and served a sentence that was not wholly unfamiliar. The situation had been otherwise processed. B, to impose upon them, as Judge Bond points out, a requirement of effective court to deduce from the Due Process Clause a rule binding upon the state fully require the appointment of counsel would require it. As incarceration of one whose trial is offensive to while want of counsel in a particular case may result in a conviction charges of small crimes tried before justices of the peace and capital charges tried in the higher courts would equally require the appointment of counsel. Require it. As we have said, the 14th Amendment out of a job and on relief. The court is clear from its examination of witnesses that he was a man of little education. In this case here, we should have to reverse it because the 6th Amendment makes the right to counsel in criminal cases. I believe that the 14th Amendment made the 6th applicable to the states, but this view is accepted today. I believe, however, has made it impossible to conclude with any satisfactory degree of certainty that the defendant in regard this country. In 1854, the court such vast supervisors Alabama, a practice cannot be reconciled with common and fundamental ideas of fairness and right, which subjects innocent men to increased danger, poverty, whether a man is innocent